Good afternoon, everyone. Thank you very much for joining us. We're pleased to welcome you to a Bridge Legal and HR Solutions webinar today. As you may know, Bridge Legal and HR Solutions is a unique consulting firm that brings employment law and human resources under one roof. We also offer workplace investigations, workplace assessments, restoration, and conflict resolution services. We'd like to thank you all for joining us as we discuss recent case law that clarifies standards of procedural fairness in workplace investigations. Before we get into the weeds here, we're going to start off with a quick introduction of myself and Michelle, who is here with me, and then we'll do a quick overview. So, Michelle, why don't you introduce yourself?
Thanks, Andre. So I'm Michelle. I'm an investigator and trainer with Bridge Legal and HR Solutions. I'm also a qualifying psychotherapist, and I help employers with conflict resolution, facilitated conversations, workplace assessments, and all kinds of processes to help ensure a psychologically safe workplace.
Great, thank you. And my name is Yandre. I'm an employment lawyer here at Bridge Legal and HR Solutions. Some of you may know me. For those of you that do not know me, I provide employment law services as well as human rights services. I also do some workplace health and safety services, which in some sense today's discussion does involve, because workplace harassment and workplace violence are part of the Occupational Health and Safety Act here in Ontario. So with that, I'm just going to go through a few housekeeping items, and then we will go ahead and get started with the actual discussion. So for today's call, just so you know, this webinar is being recorded. A link to the recording and the presentation deck will be shared with all attendees after the webinar. I'm not quite sure on the timeline, but it will be as soon as possible. Cameras and microphones have been muted and are off, so you won't be able to speak to us. But if you do want to raise a question, which we will address later in the Q&A portion of this webinar, you can actually put your question in the Q&A function here on Zoom, which you should find somewhere on your screen. There's also live captions. You can click the Show Captions CC button on your Zoom toolbar to follow along with subtitles. I believe they're automatically generated. Well, they must be automatically generated. So if that's the case, they may not be 100% reliable. Okay. Now, a quick disclaimer as well. These training materials are the property of Bridge Legal and HR Solutions, are not to be copied, shared, or otherwise distributed. Nothing in this presentation should be considered legal advice. So if you do have specific legal inquiries, we ask you to contact Bridge Legal and HR Solutions at info@bridgelegalhr.ca. Okay, so we'll start off with a bit of an overview of what we're going to be talking about today. Our agenda for the day is focused on procedural fairness in workplace investigations. To that end, we will have a quick overview of what procedural fairness in workplace investigations generally means. We'll discuss three recent cases, Marintet, Caro, and Chi, each of which discuss procedural fairness. And we'll also discuss some practical items relating to workplace investigation policies and practices. So to start off, I'm going to talk about what procedural fairness actually is, and what is it? Why do we have it? Why do we have to think about it? The Supreme Court of Canada actually outlined procedural fairness in the Baker and Canada decision. Basically, the court said that decisions that have important consequences for the affected parties require that the decision maker approach the process in a fair and unbiased manner. The individuals have a right to know the case against them, the right to be heard, and the right to an unbiased decision maker. And just as in court cases, which obviously deal with very important issues, we know that procedural fairness also applies to workplace investigations for similar reasons. Workplace investigations are also high stakes matters because they can have grave consequences for the participant's career or reputation of, for example, the complainant or the respondent, depending on the situation. Errors or omissions in workplace investigations can lead to these negative consequences. So it's very important that your process makes sure that you limit the amount of potential errors that can happen in your workplace investigations. From a business or organizational perspective, there's also the fact that a lack of procedural fairness can lead to negative can constitute a failure to act in good faith, and can also be a breach of legislation. For example, in Ontario, you have to do a investigation that's reasonable in the circumstances. It's appropriate in the circumstances, I should say. And if you fail to do so and you perhaps have a termination result out of that or litigation stem from that, you could actually be, and your organization could actually be on the hook for greater damages than you otherwise would have been on the hook for. Employee and workplace morale can also suffer if you have a poor practice around workplace investigations, which will lead to negativity or loss of productivity or similar issues. So um, we're going to have Michelle now take you through some of the procedural fairness pitfalls that have been outlined in case law over the years here in Canada.
Thanks, Andre. So obviously the list that you're going to see on your screen is not exhaustive in terms of procedural fairness errors that can occur in a workplace investigation. But we just wanted to give an overview of some of the more common workplace investigation pitfalls that we see coming up. And then on your right side, you'll see some examples of cases where these errors occurred. Sometimes it can be easier to see in an actual real world case what those errors look like. So feel free to look through some of those cases if you want more information. So the first pitfall is failing to act impartially. Any kind of overt or covert bias can render an investigation procedurally unfair. Failing to act impartially could look like, for example, giving more information about the investigation to one party over the other, or giving one party an opportunity that the other party might not have. For example, the chance to provide written submissions, whereas the other party is only allowed to provide oral submissions, things like that. So you always want to make sure that all parties to an investigation are treated equally and fairly in order to ensure that your investigation is procedurally fair. The second pitfall is rushing to judgment. And the case there, Elgert and Home Hardware, is a really good one to look at if you want an example of a case where things really went off the rails. You had a really procedurally unfair investigation process. It's really the standard for what not to do. So if you're curious about this topic, that's a good case to look at. Rushing to judgment in that case looked like the investigator making comments while the investigation was ongoing that indicated that they did not believe that the respondent was being truthful. They thought that this was not an ethical person, those sorts of things. So any kind of negative commentary about either of the parties while the investigation is ongoing will definitely give an appearance that the investigator is rushing to judgment. The next is failing to be transparent with the respondent. This would also apply equally with the complainant. So failing to provide proper information about the investigation and what it's going to look like. In the case that's listed there, Carmel and Calgary Jewish Academy, the court found that the investigation was really more of a ruse to find a reason to terminate the respondent in that case. So definitely using an investigation as an excuse to terminate rather than an open, honest, transparent fact-finding process will be found to be procedurally unfair. The next is failing to provide the respondent with a chance to respond. And that obviously is a sign of procedural unfairness, as we will see later on. It applies also to the complainant, which is what we're going to talk about when we talk about Marintet. We also have failing to provide particulars to the respondent, and the Chappelle case is listed there as an example. Obviously, before you interview the respondent as a workplace investigator, you want to make sure that they fully understand the case that they have to meet. So if they're not provided with sufficient particulars in advance of their interview, the interview looks more like an ambush or like an interrogation rather than an honest fact-finding process. And then the last one there is failing to follow internal policies. So we have sort of general standards of what is considered to be procedurally fair. And then organizations might also set their own standards for what investigations should look like. And those standards should be followed because that's part of transparency as well, ensuring that parties know this is what the investigation process is. We are going to follow it for all parties. As said, these are not exhaustive. Some other things that might come up in investigations are failing to consider all relevant evidence. So things like computer evidence, emails, notes, those sorts of things. That might be a sign of procedural unfairness. Failing to interview all witnesses. That was seen in the Elgert case as well. So there's a lot of situations, unfortunately, where investigations can go off the rails when it comes to fairness.
Great, thanks, Michelle. I'm going to go through a couple of the key items that go into procedural fairness, one of which is reasons. So this is one of the elements of procedural fairness that you have to kind of consider, and that may be different depending on which province you're in Canada as well, as I'll mention on this slide. The provisions of reasons is generally a sign that procedural fairness is being met. Basically, you've provided the reasons for your decisions. This is just like in a court case. If you've ever been in court or you've ever been subject to litigation, you know that at the end, the judge will release what's known as a decision. And in the decision, the judge will provide reasons for coming to that decision. Much like a judge, a workplace investigator is putting reasons into their work to justify what the decision is at the end based on the evidence that they've uncovered during the course of their workplace investigations. The requirement to provide reasons are usually something that goes into the investigation report, and that's usually the final report, the report that's submitted to the client, if you're an external investigator, or that may be submitted to whoever hired you, or if you're an internal investigator, that may be going to your CEO or whoever, director of HR, as the case may be. In some cases, it may make sense to actually provide the full report to the party, or providing the report may be a requirement of existing policy. So if you have a workplace harassment policy, which says at the end of the investigation, the parties will be provided with the full report, well, then you should probably follow that, because that is one of the pitfalls, that you don't follow your own policies. You're going to want to follow your own policies, especially if employees are made aware of it, especially if they've signed those policies in your handbook or something similar. In other cases, though, providing the full report could needlessly disclose information that you do not want disclosed. For example, information about witnesses or witness evidence, or something that may make workplace conflicts worse. So, maybe you don't want to have a policy that says in every single workplace investigation, we're going to be giving out the full investigation report. Maybe you want to have some flexibility there to allow your organization to decide whether some reports should be disclosed and whether some reports should not be disclosed. As I mentioned, legislation does impact this. So in the Ontario, the Occupational Health and Safety Act requires employers to provide the parties with the result of the investigation in writing. So that is to say the outcome, and also what the consequences may be, whether there's going to be some training, whether it's going to go to some kind of whether there's going to be a termination or whatever the case may be. But you don't have to, under Ontario law, minimum standards law, provide the reasons for the decision. That doesn't mean you can't provide the reasons, though. You could still provide the reasons. You can still kind of level up your procedural fairness, let's put it that way, to really get it in line with what the requirements are stemming from case law and stemming from cases that we're going to be discussing today. I mean, the report itself is not usually privileged, so there may be cases where, even if you didn't disclose it, it's going to have to be disclosed. So if there's a litigation and part of the, you've terminated someone for just cause and now they're litigating, and you're saying, well, there was a workplace investigation report that found that you had harassed somebody, so that was the reason for the just cause. Well, you may now actually have to disclose that report, so that the court and the other side is fully informed of the case against them in that litigation. So, don't count on your report being always confidential, always privileged, because it's not actually likely to be in many scenarios. The other important element of procedural fairness to think about, and which you will see in a couple of the cases that follow my spiel here, is the right to equal treatment. So equal treatment helps ensure that the appearance of bias is reduced, that the parties feel like they're on an equal footing in terms of providing evidence, and in terms of the procedure that's going to guide the investigation. Basically, both parties need to be kind of aware of what's happening and why is it going to be happening in this way. Why is there an internal investigator being hired, for example? Whatever kind of information you give to one party, you're going to have to give it to the other party in order to maintain procedural fairness. Most investigators know this instinctively. They know the parties need to be treated in a similar fashion. So an external investigator is definitely going to use a professional tone with both parties, provide the same procedural information to both parties. I'm going to interview the complainant first. I'm going to interview the respondent next. I'm going to interview witnesses after the fact, whatever that procedure may be. And of course, also ensure that they're all offered the same supports. It's not often that you let a support person into a workplace investigation, but if you allow one person to bring in a support person, you can't then say to the other person, well, you can't have a support person at this particular meeting, or whatever the case may be. So these requirements are established through case law and through legislation. As I mentioned, there's the Occupational Health and Safety Act in Ontario. Certain other provinces have different legislation, which may also establish requirements of what the procedure for a workplace investigation looks like. In Ontario, it's actually fairly loose. It just says that you have to do an investigation that's appropriate in the circumstances. But there's a lot of loaded meaning in that word appropriate because what is appropriate in one circumstance could be entirely inappropriate in another circumstance. So you always have to be mindful that your workplace investigation is calibrated in that way. So to that end, I'm gonna let Michelle take you through the three cases that we've got on the docket today, starting with the Marin Tech case from 2024.
Thanks, Andre. Yeah, so we're going to be talking about three cases that really fleshed out what procedural fairness looks like in workplace investigations. So Maritech came out first last year, 2024, and there was actually quite a bit of discussion about it in the workplace investigation community. We don't get a lot of guidance from the courts. We get a bit, but maybe not as much as we would like. So sometimes workplace investigators are left to interpret language from policies and legislation and muddle our way through based on what we know about procedural fairness. But really clear guidance from the courts is always a welcome thing. So in Marintet, the applicant was the complainant in a workplace investigation, and he submitted that he was denied procedural fairness in that process for two main reasons. One, because he was not given a summary of the evidence of the respondents or of any witnesses, so wasn't allowed to comment on any of the evidence before the investigation was finalized. And second, because he was not given the preliminary findings of the investigator, so wasn't allowed to comment on the findings before the investigation report was finalized. And the court found that the applicant was denied procedural fairness for both of those reasons. So one of these is actually a bit more interesting than the other. I find the first one more interesting, and I'll explain why. In terms of complainants not being given a chance to comment on the evidence of the respondents and witnesses, this is something that unfortunately did and maybe still does happen quite often. More seasoned workplace investigators who do this exclusively for their work probably do know that ideally you should be circling back with the complainant to give them a chance to comment on all the evidence you gathered since the complainant interview. But less experienced workplace investigators or those who are doing a workplace investigation, but it's not their main job, they might have a whole bunch of other things on their plate, may not find the time or might not think it's necessary to take this step. So this is not an unusual occurrence at all that you get to an end of a workplace investigation, you have complainant evidence, respondent evidence, witness evidence, maybe some documents, and you make your finding. And not realizing that there may be a whole lot more the complainant has to say in light of that additional evidence. So this really solidified for us that yes, the complainant has to be given a chance to respond to anything that directly contradicts evidence they've provided, anything they might have additional information about, anything that might impugn their character or their credibility. All of that should be put to the complainant for response, either in writing or through a second interview prior to the investigation being finalized. So that was really good guidance to receive. The court made some really interesting statements about why that's the case. I think sometimes there is thinking that the respondent is the one who is in jeopardy in a workplace investigation. They're the ones who might be potentially disciplined or fired if it's found that they did engage in harassment or discrimination or other conduct that's contrary to policy. But the court notes that, in fact, it is the complainant too who is in jeopardy of having to remain in a toxic workplace if issues are not addressed. And also, the entire workplace is in jeopardy if these issues are not addressed. If there is a harasser in the workplace and that doesn't come out during an investigation because it's not a comprehensive investigation, then the workplace is left with someone who engages in this objectionable conduct. So it's really important for procedural fairness to apply equally to the complainant and the respondent in all cases. And that's really what we get out of Marintet. In terms of part two, the preliminary findings, the reason I don't think that's as interesting is because that was very case specific. So you can see that the court noted that the employer's own investigation checklist required the parties to be provided with a copy of the preliminary report. So that's really where that piece comes in. It doesn't apply as generally as the first part does. This is more a reiteration of what we already knew, that employers have to follow their own investigation processes. Um, So that brings us nicely into Caro, which came out this year and speaks a little more directly to the question of do parties need to be given a copy of the findings prior to an investigation report being finalized? That was a really interesting case in that the investigator had already produced their report. So the investigator did the investigation, produced a report. They considered it to be final, sent it to their client, who was the employer. And then the employer distributed the report to the parties and treated the report as if it was not a final report, as if it was a draft or preliminary report. And they invited feedback from the parties on that report and then went back to the investigator and said, we've received this feedback. You can now edit your report. And the investigator refused. So, what we really see here is a big breakdown in communication between a third party investigator and an employer. Um, so the investigator, having refused to edit their report, the employer did maybe the only thing that they could do, which was take the investigator's findings and recommendations and implement them without incorporating the report, the input from the parties. It was then the respondent in that investigation who sought to have the decisions the employer made as a result of the investigation report quashed, claiming that the whole process was procedurally unfair because they didn't get that chance to comment on the investigator's findings. And the court is very clear in Carreau that parties commenting on investigator findings or a draft report prior to the report being finalized is not a part of procedural fairness. And in fact, they give a pretty strong caution against this process and against some of the things that can happen if an investigator is required to provide their findings ahead of time. The court makes a pretty big distinction between the investigation step and the decision-making step. They really parse that into two pieces. And they note, as we already know from Marintet, that during the investigation phase, the evidence gathering, there is that requirement to get commentary from both parties. And they say, but then when you get to the decision-making phase, that requirement is removed. You don't require the input of the parties. And they say, and this is a great line, at this stage of the process, a third-party investigator requires no less serenity than a judge. So the court is really saying that we give a lot of deference to workplace investigators making their decisions. And just like judges don't sit down with applicants and discuss, oh, this is my findings and let's talk about it. Workplace investigators don't have to sit down with parties and try and defend their findings or, as the court says, potentially be attacked by a disgruntled party. So they're really cautioning how we should think about investigator neutrality and maybe having to do that process of sitting down with parties and discuss your findings or even receive submissions from the parties. Maybe that is harmful to neutrality. I think a big takeaway from Crow is the importance of clear communication from the outset. Things did go off the rails here, partially because the investigator and the client were on different sides. They did not have a clear idea of how the investigation was to unfold. But the good thing about this is that we now have a clear statement that no, this is not a requirement. Yes, commentary during the investigation phase. No, not commentary on the investigator findings. So, having said that, earlier this month, just a couple of weeks ago, as we were preparing the materials for this presentation, we started seeing discussion about another case. And the way people were talking about it, it sounded like the federal court had said, oh, no, actually, parties do need to be given a chance to comment on investigator findings, which was a big, wait, what moment? Because we just heard in Carreau that that was not a requirement of procedural fairness. When you read the She decision, however, that's actually not what the court is saying. And I think that their findings in She do not contradict what was said in Carreau necessarily, because the facts of this case and what the court was looking at were really quite different. So in She, we see an applicant who was the complainant in an investigation saying that their right to procedural fairness was breached as they weren't given a chance to review and comment on statements from the respondent or from witnesses, and they were not provided with a copy of the preliminary report. In the end, the court set aside the original investigation findings and ordered a new investigation to be conducted. What was really different in She was first the issue to be decided by the court. So while in other cases we had a party arguing that procedural fairness was not met in the investigation process, in G, the employer actually came to the table admitting that the process was not procedurally fair. So the court didn't need to get into the weeds of was procedural fairness given to the parties. The employer was very clear at the outset, no, we know that it was not procedurally fair because not only was the report not distributed, but the parties weren't given that chance to comment, which we know from Marintet is a requirement of procedural fairness. They weren't allowed to comment on contradictory evidence. So that's one difference. The other big difference in She was that a preliminary report was produced, but it was only provided to the respondents. It wasn't provided to the complainant. So we're not seeing a general commentary here that the report needs to be given to the parties in order for a process to be procedurally fair. What we're seeing is a commentary that if you are going to give a report to one party, you have to give it to the other. A final thing to keep in mind when you're looking at G is there's a lot of talk about a preliminary report, but I don't think it's clear from my reading whether that was a report that included investigator findings. So we talked about in Carreau the pitfalls of providing an investigator's findings to the parties. Here, although we do have a preliminary report, in the federal context, that often is synonymous with more of an evidence summary. So an investigator might provide what they call a preliminary report to the parties, but it's actually a summary of all the evidence that was gathered. It may not have included the investigator's findings and recommendations. So that's just something to keep in mind as well.
Great. Thanks, Michelle, for taking us through those three cases. Apologies that I'm glowing, but I've got sun streaming in on me, which is kind of great. Okay. So I'm going to go through the takeaways from those three cases and kind of what you have to think about when you're handling a workplace investigation and want to keep procedural fairness at the top of your mind. So first thing is when you're hiring an external investigator, make sure you let them know what your process is. That is to say, your organization's process. This includes providing them with any policies or procedures that you have that are related to workplace investigations that are already in place. As you know from a case that we've already discussed, you're going to want to follow your own policies, and your external investigator is also going to want to follow your policies to make sure you're not challenged on that basis that you did not comply with your own policies. Parties need to be provided with similar communications. They need to know what the process is. They also should be provided with relevant policies, especially if they ask for them. If a party asks you, well, can I see the workplace harassment policy? You're going to want to give it to them because they're already in the process. They have the right to know how the process is going to go ahead. But you also want to explain to them, what the process is going to look like, because sometimes these policies can be a little bit vague. They can just say, oh, there's going to be a workplace investigation. And then what does that mean? Does that mean, there's going to be police coming in, or what does that mean? What is a workplace investigation? So, you're going to want to set it out very clearly what the parties can expect from your from the workplace investigations that's coming, whether that's external or internal for that matter. Some organizations, as already mentioned, do provide parties with preliminary reports. Whether this makes sense is going to depend on the situation. As Michelle mentioned before, there needs to be care taken that the actual external workplace investigators' independence is safeguarded, and they're not put in a position where they have to defend themselves from the parties to the workplace investigations. Really, it's the employer who implements the results at the end and not the workplace investigator. As we know from case law as well, if one party is provided with a summary, with a preliminary report, then the other party should be provided with that same report. You should also consider providing written summaries of evidence to each party. In the federal jurisdiction, this is very common to provide summary evidence. Perhaps it should also be in provincially governed businesses. What this means is that after you've actually collected the evidence, so for example, you've spoken to the parties, you've got documentary evidence, you've perhaps spoken to some witnesses, you can put those in a summary document of evidence and provide to the parties for their comment and their input. You're not providing them with preliminary report. This is just the evidence that you've gathered so far. So the parties now actually will have an opportunity to then respond a second time to what the other party might have said during the course of the evidence gathering. Of course, discussions with parties and steps taken with regard to procedural fairness should be clearly documented. This can be done in the report, or this can be done somewhere else. Preferably, it's something that's done in the report, but that just means that you record the steps you've taken. If you provide summaries of evidence to the parties, somewhere in the report, you should have a section that says, we provided evidence to the parties. The parties were given such and such a period of time to respond to the evidence that they saw. This party chose to respond. This party chose not to respond. Basically, a summary of what the steps you took to bring procedural fairness into the fold is important because then later down the line, if that report does get disclosed, as I mentioned before, sometimes in litigations, reports do need to be disclosed. There may be other circumstances where reports need to be disclosed. So if you've got a section that deals with procedural fairness, well, then you can point to that and say, well, look, these are the steps that we took to ensure that we followed procedural fairness, we've complied with our policies, we've given everybody chances, everybody was treated the same, everybody got a chance to respond. And then that way, you're not just defending it on the basis of what you say. You've got it in writing that this was done contemporaneously at the time of the workplace investigation. So that takes us to the end of the main content. We've got a few questions in the Q&A, but I'm gonna ask Michelle to answer as we move on to the next section. We've got about 10-15 minutes left, so we're right on time to get through a couple of questions. If there are any questions right now, please feel free to put them in the Q&A, and I will ask Michelle. But we'll start off with a question, two quick questions, but we'll start off with the first one. Michelle, I don't know how easy this question will be, so let's give it a shot. What if the complaint originates in Ontario? So the complainant is in Ontario, but the person in question resides in another country. I assume the employer would need to follow the other country's procedural rules and steps. So just so I'm clear, as I understand this, you've got a complainant in Ontario. Maybe they work remotely or a virtual environment, and there's a respondent in another country, and they're maybe sending harassing messages over the Teams or whatever software you have. Do the laws of Ontario apply in that case or that other country?
That is, yeah, that's a very complicated question. I would stamp all over this. This is not legal advice. I'm thinking way back to, conflict of laws training in terms of how we decide which jurisdiction we're going to follow. So I would think generally when I've done workplace investigations where we have that situation, where we have a party in one province or somewhere and we have another party in another province or another country, it has more to do with the location of the employer. So is it an Ontario-based employer versus where the parties are? But I would say in a case that complicated, if you're wondering which procedural fairness laws you're following, I would talk to an employment lawyer before moving ahead.
Yeah, I fully agree. In Ontario, I mean, the Employment Standards Act states that the law that applies is the law of the country or the province where the employee is employed or works. But that's not what it says in the Occupational Health and Safety Act, if that's my recollection. So yeah, some question to ask your employment lawyer. If I'm that, you can ask me and I'll figure it out at some point for you. But yeah, we can't answer that question for you in a vacuum without knowing what the situation is, and where the employer is based, etc. The other question, same person, is what do you do as an employer if you receive a complaint about inappropriate behavior, but they say they do not want their names mentioned or included in any reports or interviews? How does the employer deal with this? The complainant says they will quit if their name is mentioned without their consent, as they don't want to be part of anything, but they wanted the concern known so their issue can be addressed. Before you answer this question, Michelle, I just hope you guys are not asking us questions about actual situations, because we're not giving legal advice. If this is an actual situation in your workplace, we cannot answer that for you in a legally advice way.
Yes, good disclaimer. Thank you, Andrew. So again, not legal advice, but we do get questions really often about what to do with either anonymous complaints or complaints where a party doesn't want to go, quote unquote, on the record. This is sort of a hindsight is 2020 kind of answer. But generally speaking, when we draft policies for clients or when we do training on workplace harassment for clients and their employees, we try and make it very clear to employees and in the written policy that there is no off the record when it comes to workplace harassment complaints. Clients or workers need to know that when they come to human resources or a manager or anybody who is involved in taking complaints, when they come to them with a complaint, that if it is true, it could be considered harassment, discrimination, sexual harassment, anything like that. There really is no option to not move forward with that. And again, as we talked about earlier, the courts have talked about the fact that it's not just between the two parties. We're talking about the workplace environment as a whole. So if you have a workplace where those things are going on, the employer has an obligation to address
Yep.
it. So it's not really a matter of, you have an option to not go ahead. You're going to have to do that. In terms of keeping the complainant anonymous, there are situations where you can have an anonymous complainant. In particular situations where, for example, if a person was in a meeting with a lot of other people and they saw something happen that shouldn't be happening, it's entirely possible that you could go ahead with an investigation into what happened at that meeting without saying specifically who brought the complaint forward. But if we're talking about a one-on-one situation, that option kind of goes out the window. You're going to have to say who the complainant is, just because you can't investigate that in a procedurally fair way without the respondent knowing who's raising the concern.
Absolutely. And that also kind of brings to my mind the idea that, you can't contract out of legislation, right? The legislation is the legislation. So you can't
Yeah.
just say you agree with your employee, we're not going to enforce the Occupational Health and Safety Act in this case. Unfortunately, the Occupational Health and Safety Act, fortunately or unfortunately, says this is what you have to do. So,
Yeah.
if that person is unfortunately going to quit because their name appears on the complaint and it's a requirement that their name goes on the complaint because of the nature of the allegations, you're just going to have to, as a business, deal with the consequences of that. I mean, that is just what the law says. Unfortunately, the law does not take into account business circumstances. As much as many clients and people that I speak to wish that it did, it doesn't. So yeah, it is really focused on the employer complying with occupational health and safety requirements here in Ontario, in many other provinces as well. There's a couple of there's a statement. I'll read it to you. It is Carreau did do a summary of evidence provided prior to the final investigation. I think that's an important piece to mention. I,
Correct. Yes, that is a good piece to mention as well. So in Crow, unlike in other cases that we've talked about, it was a procedurally fair process. So it was not a matter of was the case deficient up to the point where parties were not given a chance to comment on the investigator's findings. Everything was done above the board. And then the argument was, and I should have been given a chance to review the investigator findings. So that's absolutely right. Crow was a procedurally fair process.
right. There's another question, which is an interesting one. It is if a party wants to give their evidence in a language other than English, what do you do? Hmm?
Yeah, I mean, that sounds sort of like an accommodation. So if you have a party who's
Yeah,
not comfortable, English is not their first language, I would think in most cases it would make sense to bring in a translator, make sure that they're able
interpreter.
to
Yeah,
do that. Yeah, an interpreter, make sure to do that in whatever way would make them the most comfortable. I mean, these processes are stressful enough. So even if a
yeah.
person is able to communicate in English, if that's not their first language and they would feel more comfortable in another language, that would be a fair accommodation in most cases.
I agree, and it maybe even goes towards fairness, right? Knowing one's case against you
Yeah.
is, in fact, one of the requirements of fairness. If you don't understand what's being said, you can't really
Mhm.
know the case that's being put forward against you. Another thing about the Occupational Health and Safety Act, it doesn't really care about costs. So if the employer ends up having to pay for the interpreter or whatever the case may be, that just might be something that you have to do in that scenario to do an appropriate investigation in the circumstances. So perhaps a party can give evidence in a language other than English, and you're just going to have to handle that. There's another question, also from the Q&A. What are the specific tools, formal or self-made, you use to ensure procedural fairness in your own investigations?
Oh, to ensure procedural fairness. I don't know if there's like specific tools that we necessarily rely on. Some of this is just sort of from experience. We do try and write our reports as we go along, and that's really helpful for a lot of reasons. So, kind of having a template and implement and inputting your evidence as you go along. The reason that kind of circles back to procedural fairness is that when you have your evidence all laid out like that, it kind of makes it less likely that you're going to get to the end and realize that there's a key piece that you did not let one of the other parties comment on. If you're just kind of dumping everything into your report at the end, it's far more likely that you're going to think, oh, shoot, this is actually really important. It came from a witness and the respondent didn't get to comment on it, or it came from the respondent and the complainant didn't get to comment on it. So, really, I think having your evidence organized and knowing what are the things you're going to rely on versus what are the things that are a bit superfluous so that you can make sure you're having that commentary period. That's a really good practice to follow.
And I'll mention a couple of things like, for example, templates are good. Have a template
Hmm.
for your interview process. Some questions you're going to want to ask every time as an investigator, so you maybe want to have those in your back pocket. But there are some best practices questions out there that you're going to want. who saw this? When did it happen? Those who,
Yeah.
what, where, when kind of questions you just want to have in your back pocket in almost every circumstances because it's always going to be relevant. You're always going to want to discover who was there, who saw, who heard, right? Is there any recordings? Is there any documents? Is there any additional things that you need to bring in? And having that template in front of you like a checklist to say, okay, did I ask all of these questions from each witness, from each respondent, whatever the case may be? That's very helpful to organize you, as Michelle said. It's really one of the worst things you can do is you're writing your final report and you realize I didn't ask this question, and now you have to go back to a party that you interviewed weeks ago, potentially even longer ago, and ask them one particular question. And what if the answer to that question ends up just completely changing where you're going from there, and then you have to redo a bunch of stuff that you already did, and then it just doesn't look as professional or as perhaps procedurally fair as it could have been had that question been asked from the very start. So I think yeah, being prepared, checklists, those kinds of tools, very helpful. Okay, so that's all of the questions we've got in the Q&A. I think we have time for a couple of questions that we received by email. One of which is how do you protect, and this goes to something that we actually discussed earlier about witnesses, you disclose the evidence, right? Summary evidence. You provide summary evidence to the parties. But what about witnesses? Are you going to put the identities of the witnesses? So how do you protect identity of witnesses if parties get to review the summary evidence?
Yeah, that's such a complicated one because unlike the parties who are almost never anonymous, sometimes witnesses can be, sometimes they're, and often I would say actually their names are not included in investigation reports because they're not as inherently involved in the investigation as the parties are. Sometimes policies even require that investigators don't release the names of witnesses either in their interviews or in their reports. But that becomes complicated when we think about giving both parties a chance to comment on relevant evidence. And sometimes that will be evidence from witnesses. Um, I would say, as a best practice, employers should not be assuring witnesses that they can remain completely anonymous. It's one thing to say, we will keep your name out of the report. We won't specifically say to either of the parties, yes, we interviewed this person. But in terms of the content of witness evidence, if it is something that directly contradicts something that one of the parties said to you, you are going to have to put that to the parties. Otherwise, you're not having a procedurally fair process. They have to be given the chance to comment. And should they happen to guess, oh, that evidence could only have come from this person, that might just be inevitable. So ideally, you can protect witness anonymity and have a procedurally fair process. But if you have to pick, I would say you have to err on the side of procedural fairness.
Okay, I think we've got a bunch, so I think we might have time for two more. Yeah, we've got 2 minutes left, so let's see if we can get through them. What do you think of the investigator delivering the findings to the parties but not giving them a chance to respond? And this may actually relate to a case we discussed.
Yeah, yeah. So that's a little bit different from what the court talked about in Carreau. So not necessarily handing over the findings and saying, you know what, you have a chance to comment on this, give me your comments. But just having the investigator deliver the findings either, I guess, in writing or in person, which I've had to do a couple of times. I'm not a huge fan. I think a lot of the concerns that the court brought up in Carreau are come up in that case when you are put in a position where you need to sit down with a party and tell them what the findings are. I think that does put the investigator in position where you are going to have to potentially debate your findings, defend your findings,
Hmm.
anything like that. I understand the reasoning why people might want that because the investigator is the one who can explain the findings. But in a well-written investigation report, the explanation should be there. It should be very clear how the investigator came to their findings. So I think ideally it should be either an HR representative or someone in management who should be doing that. I don't think it's necessarily the role of the investigator to sit down and deliver findings.
Okay, and I think we have time for one more, so I'll ask this last one. Um, is it an appropriate protocol to prepare an investigation report at the conclusion of an investigation that is for HR files CEO only? Each participant in the investigation would receive an investigation closure letter as a summary of the complaint, findings, and next steps, but not the complete investigation report.
Uh, I will say in Ontario, generally, yes. Things are different federally. There is a requirement federally that the report be given to the parties, but we'll talk only Ontario. In Ontario, generally, unless there is some requirement in your policy that the full report be given over to both parties, you can just prepare a summary of findings, outlining what the findings are and what steps will be taken to address any findings. So yes, generally that would be an okay practice in Ontario.
Yeah, I guess if the investigation closure letter does contain the findings and the summary of the complaint, that does comply with the OHSA requirement and the
Yeah,
next steps. The OHSA requirement to provide the outcome
right.
of the investigation. I think that could be said to be the outcome. Okay, we're now at time, so I would just like to thank you all very much for attending. We hope this session was informative for everybody, and hope you can get a lot of takeaways and maintain procedural fairness in your workplace investigations. As I mentioned at the top of this webinar, Bridge Legal and HR Solutions provides employment law, human resources, workplace investigation services, including workplace restoration services. We provide this service across Canada to businesses of every size. If you do need any assistance with a workplace investigations or you want some tips for best practices or legal services for employment law, human rights, please feel free to contact us. Our email there is info@bridgelegalhr.ca. Otherwise, you can also call us at 647-794 5442. There's also a post-webinar survey that if you have time, we'd like you to fill out just so we can know how we did and how we can improve and maybe some topics for the future if you've got any suggestions. But with that, I'd like to thank you. I'd like to thank you, Michelle, as well for joining us today.
Thank you very much, Andre, and thank you everyone for attending.
Thank you.